I'm Mike Alkaraki. I'm an attorney at Leahy Hoste, LLC, where I practice plaintiff's personal injury, medical malpractice, and wrongful death. I'm also an adjunct professor at Loyola University Chicago School of Law. Today we're going to be talking about how to handle a mediation. A mediation in general is an out-of-court procedure where the parties agree to usually a retired judge to serve as a facilitator and communicator with the view toward potentially settling a case. Before you agree to mediation, it's usually a pretty good idea to get a sense of whether a mediation may be helpful for your case. Some people do often, or with some frequency, use the mediation as an information gathering vehicle, although that is really not the true purpose of a mediation. And by the time you get there, it really should be about trying to resolve the case. With a view toward that, probably the first thing that any attorney entering into a mediation needs to be aware of is that their client is going to be put in a situation which is unusual. So just as with any other aspect of client representation, it is very important to prepare your client for what the procedure will entail, and also the really what the substance of the issues are, so there are no surprises. Part of this, and particularly in terms of my practice, which involves claims for money damages, involves managing the client's expectations with an understanding that when you enter the mediation and begin the mediation, the first offer or first series of offers may not be anything close to what it will take to settle a case. And of course, mediations are not particular to injury cases. Any type of case can be mediated. And just like any type of case, it is critical to know both the strengths and the weaknesses of your case. Typically in a mediation, after opening remarks, the parties will break up into different rooms, and the judge or retired judge will sort of shuffle back and forth between those rooms. The judge will typically try to show you the weakness of your case so that you're more flexible in terms of negotiating. At the same time, the judge will want to hear from you the strengths of your case and the weaknesses of the other's case, of the other party's case, so that he or she can make sure that a message is being sent that the other side ought to be more flexible in their negotiating position. So you should not be surprised. Nothing that's said either from the other side or the judge in terms of a weakness in your potential case should come as a surprise to you, and you should always be prepared to couch that alleged weakness in terms that frame it as really not that damaging, and that's really just part of preparing your case for trial. In a mediation setting, just like any other negotiation setting, you need to know what in negotiations parlance is called the acronym Batna. That's the best alternative to a negotiated agreement. And of course, in a litigation setting, that is usually, if not always, trial. So when you approach the mediation, you should be confident in your ability to try the case if need be. Certainly there may be circumstances where there is more pressure on the plaintiff to settle a case during mediation or after mediation through negotiations. But at all times, if you want to have a successful mediation, you must be prepared to try the case in front of a jury. As the mediation progresses, and I sort of made reference to this earlier, the judge may go back and forth between the rooms to communicate settlement offers and also positions on certain issues. It is very important during the mediation that you listen to the mediator. The mediator is going to be the person who's delivering the message to the other side. The mediator will also have insights into how you can maximize leverage in your case to get the best offer. It is tempting sometimes to revert into pure advocacy and to be defensive when the mediator comes in to discuss the case and says something that maybe is critical of your case. But it is very important in that context to listen to the mediator, understand everything he or she is saying, and really get as much information as you can so you can make as informed decision as possible, and also press the right buttons in terms of applying leverage. And part of the concept of listening to the mediator is really negotiating in good faith. What you're doing there is the mediator needs to trust you. You need to trust the mediator. There needs to be a trust-based rapport for you to get the most out of your mediation. And that is developed over time throughout the day or series of days, as the case may be in some mediations. And it's also developed over a period of years, perhaps, because you are very likely to run into and encounter and benefit from the use of a mediator multiple times. So when you can establish that you are there negotiating in good faith, you have a trust-based rapport with the mediator, and you are addressing issues that are relevant rather than wasting the party's time, the judge's time, and frankly your client's time, you have a much higher likelihood of having success in that case and in future cases mediated before or with that judge. And throughout the mediation, it is of course important for you to know, for your client to understand, that the mediation may not result in settlement. In fact, if you go into a mediation dead set on settling the case, you're probably at a disadvantage. The best position to be in is one where you are open to settling the case, but are willing to conclude the mediation without a settlement and move the case forward. That doesn't mean that settlement won't happen later, but certainly falls into the category of being ready to try the case at all times if you're going to negotiate from a strong position. And with that, I would encourage you to check out the ISBA Tort Law Section Council, of which I am a member. You can do that by visiting the ISBA website and reading all about the benefits of membership. Thanks very much.